Welcome to the monthly truck stop webinar presented by the Motor Carriers Insurance Education Foundation. The truck stops are presented the second Thursday of each month at 2 p.m. Eastern Time. These webinars are presented as industry updates for informational purposes only and do not qualify for state CE credit. If you're seeking state CE credit, email trs at ibci.net. And we'll send you the information on those presentations, which we provide 12 hours of state CE each year for our members. Move to the next slide, Jim, please. If you have any questions during these presentations, please type them in the chat window. They'll be addressed as time allows, or responded to after the webinar via email. If you experience audio problems, please send us a note in the chat window or call our office at 800-741-4084. We'll attempt to correct these problems as soon as possible. Now let's get to the meat of our subject. I've been asked a lot of times, as the states are starting to improve marijuana for both medical reasons and recreational reasons, how that fits into the FMCSA, the federal rules for drug testing in the workplace. Jim Mahoney from Phoenix, tell us a little bit about you, Jim.
Well, greetings, everyone. My name is Jim Mahoney, as Tommy said, and I practice transportation law with the firm of Resnick Louis, which has about 60 lawyers arrayed around the country. We do injury defense, and then I do regulatory work. I'm the chair of the transportation department. I do have a counterpart. Yeah, go ahead.
No, I was just going to say, you've been a friend of ours. You presented other programs. We appreciate it. When I reach out for people to help us understand these things, I appreciate you coming and sharing your information to us. And go ahead. I didn't mean to interrupt about the counterpart. Go ahead.
Well, yesterday I was at a deposition and I was asked just this question about medical marijuana in the workplace. And so I had a preview of our session today. My counterpart is Tabitha Myers. She couldn't be here today because she has a deposition, but she actually enjoys her practice in cannabis law and employment litigation. Seems to be a never-ending, evolving laws that she's very well versed in, and she and I put this together. The workplace actually is in flux, in transformation. Marijuana has become more accessible, as we know, and more accepted. 29 states plus the District of Columbia have decriminalized the possession of marijuana. 8 states allow the recreational use of marijuana. Here's a map that kind of suggests where it started and where it's going. As is usual with so many trends, it starts on the coasts and then moves inland like a virus.
Yeah. We always talk about the left coast, right? The west coast was starting in this area.
Right. Naturally, the trends that start on the coast work their way into the rest of the country, and this is holding true for marijuana.
I don't want to criticize your map, but there is and I think we're in a limbo in a couple of places here, because Florida, you say states with medical marijuana, while Florida has approved it, but have not written all the regs yet. So
okay.
There was a number of these states that came on board on the last election in January. In last November, but we're in a hiatus now and I'm sure a couple of these other states are the same way. It's, quote, legal, but actually for medical purposes, not recreational purposes in Florida, but some of the regs and rules have not been completely written as far as the medical part of it. And we get the same question. We don't have time to deal with it here, but you've heard this conflict before about even the discussions that we're having on the healthcare law about the drugs that we're taking, that this marijuana might be better for that part of it. In fact, one of the proponents in Florida was one of the major plaintiffs' attorneys that advertised this and put a lot of money behind it to get medical marijuana approved in Florida. And we get that same question: what happens if it's prescribed for work comp purposes, which is a whole different subject. But this is a growing problem of balancing the federal acts and the state acts and taking care of an individual as well as a drug testing. So I mean, this was the time we're going to spend, Jim, and I really appreciate you taking time to share this stuff with us.
Well, it's an absolute moving target, as you say, Tommy, with Florida coming on board and states trying to implement regulations that make sense in the workplace. The ADA and medical marijuana. Marijuana is not protected by the ADA as a reasonable accommodation. Most state courts find employers are not required to accommodate marijuana use for either current or prospective employees. Generally, almost all courts will hold that a drug-free workplace rule in your handbook will override medical use of marijuana.
So what we're saying is, even though it's medically prescribed and even though it's in the states allow it for employment purposes, the employer can still have no drugs, no impairment. We got a whole series of drugs, do the pre-employment testing in those areas. And the courts have said they have the legal right to say that they don't have to employ a worker who has failed a drug test due to marijuana, even though it's medically prescribed, nor do they have to accommodate the worker if they have the pain as a prescription for marijuana. This is an important part because a lot of us deal not only in the workplace that we're talking about for transportation and safety sensitive areas, but a number of states have this drug-free workplace, which is usually a part of the work comp component, which gives a credit to the various insureds based on their having a drug-free workplace that does pre-employment testing and random testing and post-injury testing. So this is very important that so far the ADA and the American Disability Act is what the ADA stands for, and that's a potential EOC complaint, does not recognize that medical marijuana is something that would fall under that protections of workers who use that. Am I phrasing that right, Jim?
That's correct. And in fact, if it's time to rewrite the workplace handbook, because almost all states will hold that a drug-free workplace rule will override the medical use of marijuana.
Okay.
Even those states that have decriminalized marijuana, the use of it for medical purposes can terminate applicants and employees who test positive for marijuana, as you said, Tommy. But there are exceptions. And I happen to practice in one of those states, Arizona. Typical in Arizona is prohibits employees from discriminating against medical marijuana users who test positive for marijuana. We should get into that a little more in a minute. There actually is no federal law that regulates drug testing in the private sector.
Most of those are imposed by the work comp carriers, are they not? Or the individual employers trying to keep this out. But I find that the carrot that drives this is most states in the work comp arena will give some kind of premium credit if you have a drug-free workplace and meet whatever that state requirement is. So I think that's the carrot and the incentive to have a drug-free workplace.
That's true.
Okay.
Yeah. But again, you cannot understate or overstate, rather, the importance of a drug-free workplace handbook policy because reasonable suspicion, testing of someone based upon reasonable suspicion, based on behavior or actions or even appearance is acceptable pretty much in every state.
May I make a suggestion here? Because I did a lot of this in Florida with the work comp area. If agents or insurance companies who are listening to this, that's something you need to put the procedure in for reasonable suspicion. Jim, what I had already talked about is that you need to have more than one person to confirm that regional suspicion. You cannot do it in kind of a way that brings in attention to that individual. So you'd have to do it quietly. Thirdly is you don't tell them to drive down and get drug tested. You take them, because particularly if they're impaired in that way. And if they then pass, if they fail the drug test, then you can adhere to whatever your drug-free workplace manual says, either termination or rehab or things like that. But if they do not fail the drug test, then you have to keep paying them. Is that some recommendations that you would want to handle this carefully to keep it out of the public arena, or at least out of the defamation problems?
Yeah, in another slide coming up, I talk about reasonable suspicion and training for that, as we do in the motor carrier industry. It's important. Probably it should be universally used in any business, but in the motor carrier industry, it's a requirement that there be a person, drug enforcement person, who can say someone has acted strangely or impaired and can be sent for a drug test. And that's a good defense to any kind of challenge by the employee under the EEOC or any other type of wrongful termination lawsuit. So the main law that regulates drug testing in the private sector is the FMCSRs. Motor carriers are obligated to follow 49 CFR Part 40, which is detailed processes about checking a transportation worker. If a transportation worker is employed in a safety-sensitive job, and that's as far as the definition goes, so you could certainly envision drivers, you can envision loaders, you can envision perhaps even load planners. He or she may not work under the influence. These people must be tested in this procedure under Part 40. There's random testing, there's reasonable suspicion, there's pre-employment, there's re-employment, and one of the most important is the post-accident testing. And the best theory that we work under right now is that if you do not need a post-accident drug and alcohol test, then you need not do it, and you probably should not do it. The statute is 49 CFR 382.303. If there's any fatality involved, then there's drug and alcohol testing. If there's bodily injury with treatment immediately away from the scene, then there is testing. If there's a citation issue. If there's disabling damage to any vehicle requiring tow away and there's a citation, the same is true, that you need post-accident testing. And again, as Tommy said, you should have the driver escorted to the drug testing facility. And that's different than any kind of testing in the employer's handbook. This is required by the FMCSA, and so this test is mandatory. You can always follow up if this test is done with another test that may be more inclusive of the types of drugs that are tested.
I'm sure you defend some of these cases, and that's one of the things the plaintiff's attorneys start fishing in that pond. Did you do that? Do they not? That part of it is along with cell phones and other things here. But this is one of the standard production if one of those three criteria are met, and there has to be some post-crash, and then they say if you did not do it, then you got more liability, because then they'll say the reason you didn't do it because they're potentially impaired. For you who are retail agents here, what you got to understand is these drug tests must be done at the crash site. And I think, Jim, is it not within the 4 hours for alcohol and 30 hours for all other substances? I think that's
correct. It has to be done, and usually done at a facility that knows how to do a DOT test. Generally, hospitals don't.
Right, that's on a qualified list. And the point I'm making to you retail agents, it's important that you get your insurance in some kind of drug test facility that has a national footprint that can drug test in those areas with an 800 number somewhere in their cab, so they can call those up and get this thing and get this done. It's also advantage to also have that same test to also comply to something that Jim's going to talk about in a minute, and that's a random drug testing, so that your 2 or 3 employees gets into a bigger pool to meet that requirement. I think right now 25% of the pool, I think that's a current level, has to be drug tested each year for that. So this will tell you retail agents to help your insureds get advice from local drug testing facilities that can administer these tests, not only the pre-employment, manage the random testing on your behalf of your insurers, and thirdly, to be in position to do the post-crash testing no matter where the accident is or the crash is.
Now, under the DOT, you're responsible for meeting all the applicable requirements and proceedings under Part 40. A designated employer representative is a trained employee who is empowered to remove immediately any employee from safety-sensitive functions. There must be training in order to be a DER, a designated employer representative. The DOT tests for marijuana, cocaine, amphetamines, PCP, and opiates.
Those are the 5, right, Jim, that required. Some of the drug-free workplaces for work comp have more than these 5. So again, your suggestion is to not elaborate for DOT rules beyond these basic requirements.
Right. If you need a DOT test after a post-accident, then you should just do the DOT drug test. You should not enhance the chances of a plaintiff's attorney finding something that could be a false positive even to use against you in the case.
I don't know if we got this. I don't think we have this later. You got a minute here to talk about the difference between a drug test involving a urinal drug test or body fluid drug test versus the new proposed hair testing situation. And the way I understand that the hair test will stay in your system longer.
That's very true. It will, especially for marijuana. It stays in your system, stays in the hair follicle for quite a long time. So if you do use hair testing for pre-employment or re-employment, then you're going to see a greater picture of the person and whether they're a user or not.
And then that can even be who they live with or who they see a lot, because the way I understand it also is not, even if you don't smoke, if you are exposed to the marijuana smoke, it can be tested through your through both hair and the other. So it's almost a lifestyle situation.
I've had personal experience with an employee when I was working for a large motor carrier who tested positive randomly for marijuana. His wife was a sufferer of MS, and she had a prescription for medical marijuana. And so we made him bring in the wife's prescription. He didn't have a safety-sensitive function. He was a claims person. So when he brought that in, he was okay. But at the time, we had a drug-free workplace environment. So if he had tested positive and hadn't been able to bring in his wife's prescription, he would have been terminated.
How does that fit in the situations where it is a DOT required part of it? Then could that become a problem where the driver is not taking of it themselves, but I understand even for the secondhand smoke, even through the urinal or through body fluids, this could also show up. I mean, I've told a number of people, go get a better roommate. That's what but this was the old days before it became all legal.
Yeah, the secondhand smoke I don't think is going to play an important part. What I understand is that behind the scenes that this employee actually did partake in with his wife in smoking marijuana. But since his wife had the prescription, we really couldn't terminate him.
All right, move on.
Yeah. Safety sensitive functions. All CDL drivers who operate commercial motor vehicles on public roads operate in a safety sensitive function. As I said earlier, there are others who are in safety sensitive functions, such as maintenance workers and mechanics, sometimes loaders, and depending on the cargo, you might want to be cautious about that, because a load loaded the wrong way can end up spilling over on the road. So that would be a question whether you should test loaders or not. But if you have a drug-free policy at work, then they're all subject to random tests. A designated employer representative. The regulations of the FMCSA define the drug employer representative training, teaching the company representatives to identify indicators of person who operates in a safety-sensitive function as being under the influence of alcohol and drugs. We could all probably spot somebody in that, but it's required by the DOT that you have a trained person. Reasonable suspicion is sufficient to require immediate testing by the DER and is protection against employee retaliation. But I would suggest that it not be taken to an extreme by targeting that person whom everybody thinks is high every day, by testing that person day in and day out. That person's going to go to the EEOC on that. But reasonable suspicion, as long as it's genuine, is a perfectly reasonable way of testing someone and perhaps eliminating a problem and a risk down the road. Generally speaking, we're now at the statutory law. 382.603 is a regulation requiring supervisors of commercial motor vehicle drivers. And that can be a designated safety person. It could be a driver, manager. It can be anyone in the safety department. Depending on the size of your insured, there may be one or two people who are trained in this. And it's not lengthy. It's 60 minutes and then another 60 minutes.
With this, I mean, what happens if you only got 3 or 4 employees, Jim? How do you, this becomes a real problem. What's the downside if they're not doing this? Is there a problem with them? You might not be protected under the EOC or something like this if the person who looks at the suspicion.
If you don't have someone trained and you end up with the DOT audit, this will be a critical violation, and then you could be downgraded to conditional or worse.
Okay, and get fined.
And get fined, yes. No driver shall refuse to submit to a pre-employment controlled substance test. Return to duty. In other words, if they're out ill or they're out on some kind of leave, there's an obligation that they have a test again, or a follow-up if they've already been sent for rehabilitation. You cannot allow a person who refuses to submit to these tests to perform safety-sensitive functions such as driving or maintenance. Medical marijuana laws are expanding, as Tommy said about Florida. We're going to see expansion of use of medical marijuana. So you probably should call counsel to rewrite your employer handbook.
Jim, don't you see this happening in most all states? I mean, I know we're balancing this between how beneficial it is or not, but look at all the problems with opioid, the drugs that we're having now, where the epidemic, again, the discussion about the health care focuses on those people who are addicted to those kind of drugs, and this has supposedly proven, even though we don't have a long history of it, that this is a relief of some of the pain without some of the downsides to it. So I see this thing, I see it expanding beyond. I think it's got legs in most every state. Do you not? Or at least the people support it.
I agree with you wholeheartedly, because I think there are a number of studies, clinical studies, that would show that medical marijuana does somehow relieve symptoms and pain, and may be a good substitute for opiates. But nonetheless, you may be able to keep them out of your workforce if that's your goal.
Let me ask you one other question about this too, and just thinking about where we're going to future. Obviously, the real key to this for failed drugs is impairment. And there are some histories as far as the alcohol consumption that once you get over a certain level, then you have defined impairment, at least while you're operating the vehicle on the highway. Right. Isn't that one of the problems here, is that we haven't come up with some concentration of the marijuana in our system that leads to impairment, or that might even be eventually impossible to deal. But if anybody's studying that side of the, if anybody's studying that side, is there a way to measure the difference between I've got marijuana in my system and I'm impaired?
They absolutely are. They're testing for THC levels as to what level is an impairment, because THC is the active ingredient in marijuana. We actually litigated that case here in Arizona as to whether a driver, and this was not a commercial driver, was impaired or not, because the drug test determined that he had marijuana in his system. That's gone up to the Supreme Court in Arizona. So every state is going to come out with their own definition. Eventually, I would say it's probably going to get more uniform as to what constitutes impairment. But
I guess, and that affects the driver's license capacity and losing the license, like the 0.02 or 0.04 in those particular areas. And this is evolving history, and we're right now in the middle of this evolving history. I mean, I think one of our advantages is that our typical workforce today, the drivers are 50 years old or older, more than half of them out there. So the new generation who has experienced all this is not coming into the driver employment arena yet. And when it happens, there could be a different view, as medical marijuana has a different view now than it did when you and I were growing up in this area. Right. I'm older than you on that part of it, but yeah.
Well, regardless of the job or the industry, even if you have a medical marijuana card, no one may use, possess, or be under the influence at work. That's still the bottom line, black line law. There are peer-reviewed studies that are finding that marijuana is helpful, but nonetheless, this is still the black letter law. You cannot use, possess, or be under the influence at work.
And so we phrased this earlier there, and this is being discussed even for money handling of this area and other things. This is where we have a conflict between a state law and the federal law. And so what you're saying, as far as the American Disability Act and as far as the rights to write these things into it without a violation of the ADA, and as far as meeting the federal requirements for steel drivers, that trumps or that oversees the state requirements to do that. And so we're governed in the federal arena for these kind of things, both the safety sensitive usage of it, or safety sensitive jobs, and also the violation of the American Disability Act, which is a big part of here, because this is where the employer would have the suit against our employee. I mean, the employee would have the suit against our employer for discrimination, and that would be protected under ADA in most cases.
Yeah, you'll find the risks that you have a driver who may have tested positive and is put in a truck, and the employer thinks, well, he's not inebriated, so he can drive the truck, and yet he has an accident. And then the plaintiff's attorney finds that he had marijuana in his system. That's surely going to come back to bite any insured.
The law also, and there's discussion also between synthetic marijuana and grown marijuana, and I know there's a law distinguish between the THC and how you get it. Is there a difference between the manufactured marijuana, or at least the impairment part of that, the health part, and the grown marijuana?
That is so brand new a field, Tommy, that you bring up, that they really don't have any guidelines for synthetic pot or any kind of synthetic alternatives to pot. It's just simply not thought of at present. I
mean, they're trying to do some THC, because that's the ingredient in the marijuana, the pot that tends to relieve the pain part of it, and that's why I think they're looking at, are they not? I mean, as far as the laboratories and things like that.
They're also looking at parts of THC that do not raise impairment but do alleviate pain. So they may come out with hybrid marijuana that doesn't make you high but does alleviate pain, and then that would be probably the key to alleviating a lot of these problems in a lot of these cases.
But again, they're going to be the rewritten of the federal law and the state law, which, I'm not sure, as old as I am, I'm not sure I'm going to be alive enough to see all this stuff coming through.
You're right. It takes the DOT a long time to get where they're going, as we see with the logging devices and the hours of service. They are just not progressing too quickly.
Well, you got another problem is the state, the Congress in Washington still sees marijuana as a drug to be enforced, yet you got the state laws, and we got to overcome some exceptions to that. You're hearing that the drug testing or the drug enforcements have been possibly stepped up, which would include marijuana, and that's going to be a big conflict between the states that have approved it or not. It's not only the drug testing part of it in a workforce, but even if you're insured or involving transporting it and those kind of things, this is going to be an evolving law. And how's your court cases, Jim? You mentioned a few of those.
Well,
how have they come out?
Under the prior administration, there was something benign neglect. Federal prosecutors would look the other way because of medical marijuana. They could prosecute it for possession or for use or for being intoxicated, but they didn't. That may or may not change depending on which attorney general we have in the near future.
All right. Is this the whole? Go ahead.
That's about it. That's if anyone has any other comments to make, I'm happy to chat with them offline.
All right, we will do this part of it. Jim, tell them, I don't think I have a slide here how to contact you, but tell them how they can contact you.
Oh, sure. My phone number is very easy. It's almost obscene. It's so easy. It's 602-900-1800. Sounds like a
Do
chat
that.
line, but it's not. That's me.
Do it one more time.
602-900-1800.
And I'm sure you would talk to the agents who, the audience that we have here, obviously, are the insurance providers who are the best messengers back to the insureds to walk through this continuing problem, because I'm sure the employees are pressing on this, particularly in the states that have allowed this part of it. And it's an ever raising thing where we have a problem from a requirement here, post crashing problem that would be involved in the impairment if for the driver, that would also cause more dollars. The ADA situation where it is prescribed for medical, but we don't, we might possibly have discrimination, and balancing that with the drug-free workplace involving work comp. So this is a whole thing as we evolve through this.
I recently spoke with a fuel delivery company. They deliver in northern Arizona, and the owner said he has a problem because he has drivers with medical marijuana cards. And I said the easiest way to close that problem is to rewrite your handbook and have a drug-free workplace. And then you can tell those drivers that maybe they'd like to work in dispatch or something else, or maybe they'd like to give up the medical marijuana.
And if you have his advice, the way I understand it, if you write a new reg like that, you have to give a period of time for the current employees to now adhere to that new reg. Would you not? You couldn't do it automatically without giving them time.
No, you'd have to give them a little time, but you'd also want them to sign off on the new policy.
Right. Yes, that part. But enforce it 30 days out or something. So then go to the doctor and get another prescription. That part. All right, Jim. Is that all we got then? Right?
Yes, sir, Tommy.
Appreciate your time, and hope you all who are listening to this got something out of this. Again, we'll visit with Jim later as we see more and more of this becoming a law, and more of this become as the court systems and as the states deal with this, as well as the federal. Jim, thank you for your time. We appreciate everybody who's attending this truck stop. We look forward to seeing for everybody to attend the next truck stop, and we're out of here.
My pleasure. Good day.
Thank you.